Hello, and welcome to our Business Organizations Midterm Review for Professor Ponte's Business Organizations class. Please note that the materials covered in this overview are just highlights of our course materials. For greater depth, go back to your textbook, the slides on TWEN, and other classroom materials. If you have any questions on these highlights, then feel free to reach out to me either by email for brief questions or during office hours for longer discussions of course materials. But keep in mind that this review just covers the highlights of unincorporated entities that we have covered up to the date of the midterm. So keep in mind, further materials, deeper dive, go back to your textbook, slides, and other class materials. Please also note that this is an updated version of a pre-recorded class review. So you may hear some back and forth with students. That comes from an earlier review session of the same materials. So this will be our starting point, is that this is already a pre-recorded class review, but I am giving you now a slight update on those materials. But feel free to reach out to me if you have any questions or concerns about the review. All right, let's get started. All right, we started out the very first class, we were looking at sole proprietorships. We talked about the fact that they're not a separate business entity. The owner and the business, they are one and the same. This used to be the most popular form of business entity because it was the easiest to form. You basically just started doing business. And the only thing you might have to get is a fictitious name certificate. So if your name is Mary Smith, but the name of your company is Harry's Pizza, well, then you might have to have a fictitious name certificate so that people will know who's behind Harry's Pizza. It may be, Harry might have been her dad or her husband or her son or whatever, but fictitious name certificates allows the public to know who is the individual who owns the business. Then you might have to get a sales tax permit because that's always out there for services or goods. And then if there are other licensing obligations, if you're running a restaurant, there might be health code issues that you have to address. But there's really no separate law that governs sole proprietorship. So there's like no sole proprietorship law because you and the business are viewed as one. We talked about these issues that you should always think about, and if you go throughout all of the slides, that would be what we've been doing so far this semester, right? Management control, liability concern, funding options, profit and loss, taxation, business continuity, and dissolution. These are sort of the key features of all the businesses that we have been looking at this semester. So when you think about the sole proprietorship, we've already talked about they're the sole decision maker. That can be good if they're a very effective person in marketing and management and in the field they're working in. That can be bad if they are not that good in these areas, and they may have difficulty attracting sufficient talent because people don't see a career path for themselves. They have unlimited personal liability because they and the business are one, right? We saw that if we look at the shiplets where the Copelands try to say, oh, well, the business is separate from us, and the court said, you're a sole proprietorship. You and the business are one. You have unlimited personal liability. Funding options might be more limited because you've got to work from your own resources, or you may have a hard time getting people to give you capital because you're a sole proprietorship. And in many cases, a lot of people who are sole proprietors, they run out of gas pretty fast because they don't have enough capital. So they oftentimes rely on debt like loans from a bank or credit to get themselves through. Profit and loss, though, if you're successful, you get all the profits. If you're unsuccessful, you suffer all the losses as a sole proprietor. When you look at tax issues, individual tax return, that's what you're filing, and then you're going to have to justify any business expenses or losses that you're going to try to deduct from your individual tax return. Unlike other business entities, it really has limited transferability because the business and the individual are one. So basically the business's value is very closely tied to the owner. And then dissolution, of course, one of the key ways is death of the owner can terminate the business entity. Any questions, folks? Just stop me if you feel, all right? So that's the basics. But think of these things that you see in green. These are really the things you should be thinking about for these different business entities that we've covered so far this semester. All right? If you remember, we also talked about the fact that agency law is very important as regards business organizations. Once you sort of get past the sole proprietorship and you're tending to deal with businesses that have two or more parties to them. And we talked about the notion of agency relationships are all supposed to be consensual. The parties are agreeing to participate in this relationship, which creates the fiduciary duties, the duties of trust that are owed by the agent to the principal. We know the principal gives authority, and we'll talk about the different ways that they do, and the agent is supposed to receive and act on that authority in a manner that carries out the goals and objectives of the principal. What are some examples of agents owing fiduciary duties? The general partner. In the general partnership, the limited partnership, the registered limited liability partnership, and the limited liability partnership. If you're the general partnership, if you're a general partner, you're an agent. You're an agent. When you talk about the member manager in the LLC, the person who's not just an owner, but is actually managing the business, in the LLC and the PLLC, they're agents. Limited partners in the limited partnerships have limited fiduciary duties. That is, they at least have the duty of good faith and fair dealing, but not much beyond that. And then the manager non-member in the LLC, that is, I'm not an owner, this is a manager-managed LLC. I have the fiduciary duties owed by an employee. Ryan, do you have a question?
No, I'm sorry.
Okay. So just keep this in. So these are some of the examples that are out there, folks. Now, remember, I see a lot of you typing away furiously, and that's good. But remember, these slides are already posted, so just add to them, right? They're not extensively different from it, but just keep in mind, it's sort of pulling it together. Also, look at those charts that appear in a lot of the ends of the chapters that try to give you some good comparisons, both between the different organizations as well as the organizations under different laws that might govern them. All right? And when we talked about agency relationships, we probably felt like, oh, God, we talked about agency plenty. We did, maybe too much, but that's the way it goes in business associations. It's a key foundational principle, right? Remember, actual authority. We talked about this at the time, and people, I think, were still a little bit confused. It can be written or oral. It can be expressed. That is, the principal lays out to you what your instructions are or what your obligations are. But it can also be implied. That is, you might say, well, as a reasonable agent, I believe to carry out the instructions that have been given to me by the principal, I may need to carry out these other acts. When you're talking about actual authority, it's how the agent views their authority from the principal. It's where some of you were getting a little confused last time. So say you are the superintendent of a building, and you certainly have a job description, and that tells you kind of what your express authority is. But there are certain things that they might expect you to do. So say your responsibility is to keep the dumpster area clean, right? That's one of your express duties. Well, you might have to buy trash bags sometimes if it's overflowing, if the trash truck hasn't come yet. Do you say to yourself, well, it didn't expressly tell me to get trash bags? Well, a reasonable agent would recognize that that's implied from their actual authority. If I'm going to carry out the authority of keeping the area around the dumpster clean, there's some extra things I might need to do to carry that out. So it's reasonable beliefs. It can't be sort of irrational ones or ones that are outside of the bounds of the norm. All right? Apparent authority is the way the principal displays or manifests the role of the agent to third parties. So it's not what the agent believes their authority is, it's what the principal has led a third party to believe the agent has authority to do. So you're looking at the third party's reasonable beliefs. So think of actual authority as the agent's reasonable beliefs and apparent authority as the third party's reasonable beliefs based on based on the principal's manifestations or conduct to them about the role of the agent. that can raise this issue. We talked about the estoppel theory of recovery. Basically, if I've relied on the manifestations that you've made as a principal as regards somebody's authority, then if I am injured by that, then I still should be able to go after you, even if you claim they didn't have actual authority. You led me to believe that they had this authority. So it's really to protect sort of innocent third parties from the principal's manifestations. And if the principal is intentional or careless in their actions, they can cause this reliance. And if they think they have caused that reliance, then it's really their duty to notify and make others aware that the agent doesn't have this authority. December.
I know it's important as part of the just general concept, but test-wise, so how deep should we go on reasonable? Because it's
Well, reasonableness is that objective standard. I mean, so reasonable in what sense? How much deeper would you go? December, I guess let me ask you that.
well, I'm kind of trying to be tactical here because it's short essay, so I imagine and I could be wrong, and I know you can't tell us this, but a whole lot of convincing to do on whether they're reasonable or not. But I mean, like,
Well, it's kind of a fact-intensive review, though, right?
yeah, and that's what I'm kind of thinking. Like, okay, we'll have the principal's manifestations, but what do we need to prove about the third party to say that they had a reasonable?
Well, you'd look at the facts and say, objectively, if somebody was to look at these facts, would they have a reason to believe that the agent is authorized to carry out this conduct?
So should that be part of the IRAC since it's part of the
Sure,
element?
because remember, it's the principal's manifestations to the third party, but those beliefs have to be reasonable.
Okay.
So that help a little bit?
Yeah.
So keep that in mind. It's not just what the principal does, but also whether the person viewing is actually, you can't have irrational, or things that are outside of the bounds of the norm and say, well, you're liable for apparent authority. Well, wait a minute now. There's always going to be this objective approach to it. All right, but that's a good question. Other thoughts on it, though, folks? But as they say in late night TV, but wait, there's more, right? So there's more, and you never get rid of agency authority. It's just always there. So there's inherent authority, right? This is when you're saying that it's possible that the agent lacks either actual or apparent authority. Might the principal still be liable? They can, if what they're doing seems inherent in their title or their role or their prior conduct. So the person who you might see cleaning up the trash around the dumpster, and they're supposed to be the one who's helping to maintain the building, maybe their title is facilities manager. Well, that might lead you to believe, well, that title suggests that maybe they can fix other things at the facility, a broken step or the air conditioner in the apartment. So look at what the title is. What's the role? What has the role been for that party? Have they taken on that role of being not just the person who cleans up the trash, but does a lot of other things and fixes up things around the apartment building? Or prior conduct, right? What if in the past you've asked them to assist and they've done these things? So it could be inherent authority, another form of agency authority. And then, of course, there's always ratification. It's that idea if the principal says, well, they don't have actual authority, and they don't have I didn't manifest anything, and I don't think the authority is inherent in their role or prior conduct or their title. Well, if you hang on to the benefit, you can't later on say, well, the benefit of this guy, say, going around and doing all this fixing, you can't say later on if they fixed my air conditioner and it falls out of the window and damages somebody's car below, that wasn't within their authority, sorry, I'm not responsible. Well, you accepted the benefit of their doing this kind of work around the apartment building. So after the fact, you can't say now, oh, the agent lacked authority, therefore I'm not liable. So if you accept the benefit, then you're going to, unfortunately, have to accept the liability that comes along with it. Now look at the Shiplet case. It's a great example of all these different forms, right, of agency authority. Where they gave the guy business cards, and they shared things on the license, and they filed government forms, and they sold cars, and, there's just so much of that. It's a very rich case on the issue of agency relationships. Question on that? Done.
Is illegal activity justification for the ratification?
Say that again, please.
Illegal activity.
What about?
In Shipley, they illegally allowed the guy to use the dealer license plate, because that's only for family members of auto dealership. But the consumer didn't know that.
Right, so you could say that's an apparent authority issue.
Even though it technically is a criminal act, it's still, we're still
I
gonna.
remember I told you, they did lots of things there that definitely were shady. From probably perjuring themselves on government documents to get those, you know what I'm saying? But keep in mind, hey, they can't later on say, hey, he's not my agent when he sold that car, because in essence, they benefited from this kind of symbiotic relationship around the licensing for the vehicle. Because remember, they didn't have enough sales on their own. They needed him to kick in sales for them to even qualify for a dealer license. So they clearly benefited from that. We also talked, if you remember, we had a great discussion about the Democratic Republic of Congo, right? That's the Themis case. That's the idea, is what's the responsibility of the third party to confirm agency authority? And this comes up in cases typically where it appears there's apparent authority. Well, when you look at that case, the court said, well, wait a minute, your duty to inquire, your sort of objective obligation, you've got to look at the facts or circumstances. Are they the kind that would put a third party on alert that they need to ask a few more questions, that they need to inquire? Was the transaction extraordinary? And was it so novel that it presented a likelihood of fraud? And in that case, the court said, there's nothing there. There were no facts there. They had signed a ton of these things in the past that had been very routine part of their banking and debt relationship. The transaction was not extraordinary. They'd get the paperwork, sign it, and continue to extend their debt. And the novelty of the transaction it wasn't novel at all, and it had been signed by high-level folks. So the court said they didn't really have a duty to inquire. But of course, you could always look at a secretary's certificate or an opinion letter to find out whether or not somebody actually does have the authority to find. But you're not objectively or affirmatively required to do so unless these elements are met. So take a look at Themis on the duty to inquire. Fiduciary duties for the agent, just go through them, folks. I don't think they're very hard. You probably know a lot of them just from your discussions in tort, or perhaps if you've had employment law. But your duty of performance, this idea of good faith and fair dealing and obedience to the principal's instructions. Your duty of loyalty and confidentiality, placing the interests of the principal above all else. No conflicts of interest, no secret profits. And if there's proprietary or trade secrets or other confidential information that the principal doesn't want you to disclose, you're not allowed to do so. The duty of notification and disclosure, that's that idea that you've got to keep the principal fully informed so that they can make appropriate decision-making based on full facts. So be careful about making certain that you're disclosing all the relevant information. And then the duty of accounting. If you have funds or property from the principal, you're not supposed to commingle it with your own materials. And you're also supposed to make certain that you are able to later on clearly justify your uses of the principal's funds and property. And you're liable, if you go outside of that, for breach of your fiduciary duties. But there are also some fiduciary duties owed by the principal, not as many as owed by the agent, but of course the duty to compensate, which is to pay someone the agreed upon amount for the work, or to provide them with the necessary money they need to carry out the goals and objectives that you've provided them with. The duty of good faith and fair dealing. You're not supposed to hinder the efforts of the agent to carry out their obligations, and you're supposed to give them the tools that they might need to complete the task that they're involved in. And then the duty of reimbursement and indemnification. That's the idea that if they have spent things on behalf of the principal in carrying out their authority, they're supposed to be reimbursed. And then if, for example, somebody tries to sue the agent suffers some kind of loss because they were carrying out the principal's goals and objectives, well, there's this duty to indemnify. It's the old sort of respondeat superior situation. And remember, the principal can have liability both to the agent and to third parties. Clear on that, everyone? Okay, that's relatively straightforward. All right, governing law. So when you're thinking about, I've kind of grouped these all together by category. When you think about what are some of the key differences between these business associations under the governing law or under the liability issues, under the disassociation or dissolution, just sort of look at the big differences. So with general partnership, we've got RUPA and UPA, right? Big differences is if you look at RUPA, that's the entity approach, the partnership. The general partnership is a separate business entity. If you look at UPA, it's the aggregate approach, which is that there is no separate entity, that the partnership is made up of each of the individuals who are participating in the general partnership. And it's not really easy to convert because it is just about the individuals, whereas under RUPA, it's pretty easy to convert to other business organizations. Rebecca.
For exam purposes, are you going to tell us what state we're in, or are we going to have to know?
No, I'm not. You're not going to have to know. I'll try to be as crystal clear as possible in the call to question whether I want you to use RUPA or UPA or whatever. So I'm not going to say it's Florida, ha ha, figure it out, you know. So just or South Carolina, or Louisiana, you know. No. So I'll actually tell you in the call to question. All right. And then you've got registered limited liability. Remember we talked about this. This is primarily when you're talking about professionals that are licensed. So you have to adhere to very specific registration requirements. It can't be created orally or by conduct like you create the general partnership. Just keep in mind that it may be certain licensed professions that it's limited to by statute. And then we talked about the statement of qualifications. So if you're in Florida, you file a statement of qualifications saying everybody here is properly licensed under Florida law. And if you have offices in other states, remember, foreign doesn't mean other countries necessarily. It can be just other states. Recognize that you should give them a statement of good standing that says everybody in the entity still has a license and is allowed to practice in your given state. All right, so that's the governing law. Think about that. For the limited partnership, it's UPA is not discussed that often. It's mostly WUPA and UPA 2001. Those are the more modern ones. Yeah, there's still a few states that do the Uniform Limited Partnership Act, but that's a small number. Most do WUPA or UPA 2001. If you follow UPA, the limited partnership is not perpetual. If you follow UPA, it is perpetual. It has the potential to be so. And then you're going to file that certificate of limited partnership. But remember, if you don't follow the right paperwork, you could be treated as what? General partnership. We know that's the bad one. You don't want to be that, right? And then the limited liability, limited partnership. Under RUPA, there's no triple LP at all. There's just the limited liability partnership. Under UPA 2001, as I told you, this gross expansion of business associations, well, it allows for both the LLP, the triple LP, and the LLP. And so the main thing is that the fact that a limited partnership has the right to convert now to the triple LP. But you can make that choice of what you're going to follow at the time of formation. And then limited liability companies, they're perpetual duration. That's the benefit of being like a corporation, which is that they can continue on beyond the life of the members. And you have the ULLCA, which was amended. That gives you the basic default rules for the limited liability company. You're filing that bare bones certificate or articles of organization, which I told you is very simple. It's a page or two. And there's a ton of forms out there for that. And then always be mindful of the fact that if you don't necessarily substantially comply with the registration and filing mandates, you could be treated as a general partnership. John, do you have a quick question?
With the articles of incorporation for a company, the articles of organization, to me they're interchangeable. It's a creational paperwork. But
what do you mean by?
If we call it that you have to file the articles of incorporation.
Well, it's articles of organization, so stick with that for the because if you incorporation, remember these are still unincorporated associations, so they're not going to be viewed as corporate articles of incorporation. So we'll just be careful because remember then you're moving into the S corp and the other stuff. So this is just the limited liability, although it borrows done from some of the attributes of the corporation, it's still an unincorporated association. So it's articles or certificates, yes. Because if you're using that word incorporation, then you're talking about corporate entities. If you're using the certificate or articles of organization, that's the limited liability company. So do note that distinction. That's more for your own. I'm not going to try to trip you up on, but just realize that that's something to keep in your own head for practice purposes. We talked about the different ways that you can form the general partnership.
right? It can be done in writing, right, which you should do, because it spells out everyone's obligations. It can be an oral agreement, but that is crazy, because especially over years, people forget what they agreed to, or there's a dispute about what was agreed to. And then Freddie and Ellie, right, our big hair band there, the guy with the furry jacket on, right? It's by conduct. You can do it inadvertently, so you've got to be careful about that, because the general partnership is such a wide-ranging kind of entity that you can create it either in a written partnership agreement, you can create it orally, or inadvertently by your conduct. And that's what the Freddie and Ellie case was all about. The court had to objectively determine whether or not they had created by their conduct a partnership, even though they didn't have any kind of formal written partnership agreement, and they didn't expressly tell him they were in a partnership. There was all this disagreement about it. So you're going to look at what are the key signs that someone objectively may have created a partnership. Most important, the power to manage and control the business. Remember, he had no control, no decision-making authority. The court said he was really more like an employee. The power to have profit sharing between the parties. He got some kickback, but he didn't share the entire profits of all of their music, and he pretty much got the cut they were willing to give him over time. The idea of sharing business losses. They didn't have to write any check anytime the band had a tour and had expenses, or if they lost money on a tour. Contributions of capital, we don't have any of that. There's no showing he put any money into the business. And then joint liability to creditors for business debts. Well, he didn't have any responsibility for the debts of the entity. So the court said he didn't objectively really have, didn't really become a general partner in this band. And that, again, main thing is power to manage and control profit sharing between the parties. All right? The way to create the limited partnership, you file a certificate of limited partnership. So you're not allowed to just have some kind of oral deal that you've agreed to, or some kind of conduct that creates it. There has to be this certificate. And you're going to identify who's the general partners and who's the limited partners, so people can decide whether or not they want to invest. Keep in mind that, the idea is to give people notice that there are partners who have unlimited liability and that there's partners who have limited liability. So you want to put people on notice about who's running the operation, but also who might be liable in an unlimited way. Under RUPA, careful not to use the name of limited partners in the business name, because that may create apparent authority. That is permitted under UPA 2001, but it's not. So think about these areas where there's sort of a natural break or distinction between the sets of laws. Your duty to amend it, right? The limited partnership certificate. Well, if you're bringing in new general partners, people controlling the business, or if you're having the withdrawal of a general partner, or if you're going to continue the business after the general partner has withdrawn. So there are some things that require you to amend that certificate over time. We did talk about this, and this is true of a lot of the business organizations. If you can show substantial compliance with your filing responsibilities, then most courts will say, well, if you made an error on a filing or whatever, if you substantially complied, you'll be treated as the limited partnership. If you didn't, then you risk being treated as a general partnership. So that's sort of a fact-intensive determination. And if you yourself discover any deficiencies, you're supposed to go in there and correct the filings, amend them so that they accurately reflect what's going on. Otherwise, you might have to renounce future profits to avoid being responsible for what's happened. The role of agreements versus default rules, this is pretty standard throughout all of them, right? If you've got the partnership agreement, right, that goes with the general partnership, the limited partnership, the registered limited liability partnership, limited liability partnership, and the triple LP, right? They all have a partnership agreement. The LLC and the PLLC have an operating agreement. Those are sort of, when the court has a question, that's the first place they'll look, either at the partnership agreement or the operating agreement. Realize that you can customize a lot of the various rules through these kinds of agreements. So you can change up what the fiduciary duties are. As long as you don't fall beneath good faith and fair dealing, you could limit, for example, what their obligations are, say, in loyalty. Can they only work for you, or can they work with others as well? Can they compete with the business entity or not? Look to the partnership or the operating agreement, depending on the entity. Remember, you can make changes in fiduciary duties as long as the court doesn't find that they're manifestly unreasonable. So it's up to a court of law to make that determination, but you have a lot of opportunity to customize. Now, you should know this by heart, right? The default rules apply unless what? If the partners or members fail to agree, if the operating agreement or partnership agreement is silent on an issue, and realize some of the rules are waivable, so you gotta look at the statute, others are not waivable. So that's true of all these business entities. So there's a lot of overlap, folks, a lot of similarity between them. Questions on that, folks? The idea of the default rules and when they apply and how you can customize. Okay. The operating agreement can be written or oral, but again, that is insane to have an oral one, but people do. But recognize that, again, you can customize it, and when you've got the LLC, go back to the Goldstein case where they customized themselves right out of any authority because they allowed themselves to get fired by Goldstein's company there. So keep in mind, you can be member managed, that is, all the people who are the owners in the LLC can be involved in the daily operations, or you can basically hire it out to a third party, manager managed. Remember the SDG company, which was really run by Goldstein, but they were the ones that were operating the apartment building. So just keep in mind, and if you're going to be manager managed, you vote by the members to determine if there's going to be a specific term for the managers, deciding whether or not the managers need to be members, right? They can say, no, we're just going to limit it just to members who are managed. We can have outsiders be it as well. And then again, these filing of statements of authority saying you can act on behalf of the LLC, or a statement of denial saying you no longer can act on behalf of the LLC. So go back to the OA to see it. Look at Goldstein's a good example of that. Voting. There's a lot of similarities here, right? Summers case, our trash guys, we talked about them quite a bit, but it was a great straightforward case. Ordinary course of business in the general partnership, the RLLP and the LLP, because that all draws from the general partnership. Ordinary course of business, majority rules. Outside the ordinary course of business, unanimity is required. If you look at the limited partnership or the triple LP, right, the only ones who get to vote in general are the general partners. So for the day-to-day operations, majority rules, anything outside of the ordinary course, unanimous. And then the limited partners get opportunities to vote in very limited circumstances, such as if you're going to add a new partner or if you're going to amend the certificate which created the limited partnership, the certificate of organization. The limited liability company, the member owners are the ones. Not if you are a manager who's managing, but you're not a member, you don't get a vote. It's just the member owners. Ordinary course of business, majority, outside unanimous. That's pretty consistent, folks, throughout this, unless you decide to customize the vote. So it's pretty straightforward between all of the different business entities. Allocations versus distributions. We talked about this, right? The fact that you have an allocation, that each of you are allocated $50,000, but you decide to take $25,000 and plow it back into the business, you are taxed on your allocations, not what you actually get in your pocket, which is the distributions. Always keep that in mind. For the general partnerships, the RLLP and the LLP, the default rule is equal sharing per capita. So if there's 3 of you, you each get a third of the profits and the losses. In the partnership agreement, you could customize it to say pro rata, based on how much you actually contributed to the business entity. Keep in mind, amount of profit on the individual tax return is the allocation. Distribution is the amount that you actually get as the partner. We talked about with partnerships, all kinds, you've got pass-through taxation. So you are taxed on your individual tax return. The partnership files an informational tax return, basically so the IRS can catch you if you try to cheat on what it is you claim you got out of that partnership. Member in Meinhard, he was able to assign his distribution rights, that is, what would be given to him in cash at the end of a given year, but you in general cannot assign your partnership rights. So you can't all of a sudden say, I'm tired of being a partner, I'm going to hand it over to Shay now. No, the idea is I could hand over the money I'm getting annually to Shay, just as Meinhard did to his wife, but generally not your partnership voting, governance, or management rights, okay? So keep that in mind, allocations versus distributions. For the limited partnership, again, look to the limited partnership agreement. How does it spell out how you're going to share these profits and losses? Under ULPA, it basically says it's pro rata based on your contribution. Under ULPA 2001, it doesn't say anything except for distributions are based on value contributed. So it's kind of the same idea. It's probably pro rata unless you can show otherwise. Pass-through taxation, same idea. You're doing it on your individual tax returns. And then you've got the same idea of profits doesn't equal distributions. You could earn profits in the limited partnership just like the general partnership, but not distribute them. And again, you can assign your distribution, but not your partnership rights. That's the same between the general partnership, the RLLP, the LLP, and the limited partnership. So it's all pretty much, there's a lot of overlap here, folks, between the different business entities. The LLC, default rule, per capita allocation, very similar to the partnership. Because remember, the LLC is a mix of the partnership and the corporation. So it's the equal sharing of profits and losses unless you agree otherwise. So go back to that operating agreement. You could decide you're going to do it based on your pro rata allocation of what you actually put in, what you contributed. That's up to you. And then pass-through taxation, right? Again, individual tax returns. Now, you have the choice because you're this hybrid between a corporation and a partnership to decide how you want to be taxed. You can check the box and be taxed as a corporation. This is a tax issue now because we're seeing a lot more benefits or lower taxing amounts for corporations. So you have to decide, well, which is going to be more beneficial from a tax perspective. If it's 2 or more members, the default rule is that you're taxed as a general partnership unless you check the box otherwise. And just like the others, you can assign your distributions, but not your member rights. So again, folks, a lot of this is the same, just clothed behind a different business entity. Liability, right? If we're talking about the general partnership, we know it's joint and several liability, and it's unlimited personal liability. The partnership is liable if the party is acting within the scope of ordinary business, the scope of their authority. If they're acting outside of it, the partnership's liable if it votes approval of it. The third party did not know or have a reason to know that the partner lacked authority, or the partnership ratified the action by retaining the benefit. So that takes us kind of back to our discussion of agency authority. The partnership is not liable if you're acting outside of the scope of ordinary business, outside of the scope of your authority, and there's no vote by the partnership to approve what you've done, or the third party knew or should have known you didn't have authority, or the partnership made it clear we're not going to ratify this action. So if you go back to Summers, when he hired the additional worker, he was like, no way, I'm not paying for that. I'm objecting to this spending. Well, he was, even though it may have benefited the business, he had a good argument that I did not ratify that action. And we talked again about statements of authority and statements of denial. Do you have the authority to act on behalf of the partnership or not? All right? If you're looking at the registered limited liability, this is why a lot of law firms have gone to the LLP model. You have full shield under that, most states, except for the 2 that are partial shield. But most give you a full shield, including Florida. Look at the Promedicus case where they were dealing with this issue of how they were going to be treated. Was it full shield or partial shield, more like a corporation or more like a general partnership? If you have unlimited liability for your own tortious conduct, so you're always still liable for your own mistakes. That's where the role of insurance comes in. No personal liability for the torts of the other partners, and no personal liability for the commercial, contractual, or other obligations of the partnership. Like if they had a lease or anything, you're not responsible for that. All right? And the idea is it's going to be satisfied, hopefully, out of the partnership assets. Unless you're given a personal guarantee, they can't come after you. Now, in the partial shield states, you have the same thing. You're still liable for your own torts. You're not liable for the torts of your fellow partners, but you can have personal liability for the commercial, contractual, or other business responsibilities of the partnership. So if somebody goes after you, say there was a lease that was signed, and you didn't sign a personal guarantee, if you're in a partial shield state, they'll try to satisfy it first out of the partnership assets, but if they can't, then they can come after your personal assets. So just keep that in mind, full shield versus partial shield for the RLLP or the LLP. I can tell you this is just, you are excited now. You're thinking, oh my, this is where I want to spend my life, is doing this. I can just tell by the glazed over look of each of your eyes that this, you cannot wait. But give us more, Professor. We can't bear to leave. All right, limited partnership liability, right? Go back to Norton. General partners, unlimited personal liability. They're managing the business. That's that whole idea that, hey, they're responsible for the day-to-day operations. They're going to be liable. So they're liable for everything across the board. Now, what happens if you have an LLC or a corporation that's a general partnership? That's what they did in Norton, right? Then you're really restricting liability because of the nature of the business entity you're using to manage the general partnership. So normally you can't go after them unless you can show fraud or other illegal acts or breach of the fiduciary duties, which would allow for piercing the veil of the LLC and going after the, that's very hard to do. Piercing into the corporate veil and the LLC veil is extremely difficult to do. So unless it's some kind of wild illegal conduct, it's too bad. If they have if you've got the limited partnership and the limited partners are an LLC or a corporation, you're not going to get to go after the individuals. You go after the business, but that's about it. With the limited partnership, think about the Shimco case. Remember the lawyers who got scammed by the scammers that they were representing? Do you remember that? And they said, well, you should have known what was going on there. Well, under RUPA, if it's a limited partnership, then basically any loss that you would suffer is limited to the investment that you made as a limited partner. So they can't go beyond that unless you try to manage the business. Then you are basically turning yourself into a general partner. That's the control rule. And that's what the lawyers try to argue. Hey, these people are really controlling the business, therefore they should be liable. So if the limited partner manages the business like a general partner, and if you're a third party and you reasonably believe that the limited partner is a general partner, then liability attaches. But remember, the court said, hey, you're lawyers, you're representing them. If you go back to the organic documents that created it, you would see he's listed as a limited partner. So you didn't have a reasonable belief. You should have known he was a limited partner, so we're not going to help you out. Now, you don't have the control rule under UPA 2001. So if you're listed as a limited partner, you are a limited partner. That's it. Now, keep in mind, under RUPA, we talked about these safe harbor activities. There's some conduct you can be involved in that doesn't turn you into a general partner. So you might attend some meetings. You might reach out to customers to see if they're satisfied. You might be hired to act on a narrow project as a consultant. Those kinds of things might still be okay because you're really not the decision maker. All right? We clear on that? Questions on that? Okay. More are liability issues, right? Triple LP, we know that this is the best you could do in the limited partnership area. The general partner and the limited partner, they don't have unlimited personal liability. It's a full liability shield, so everything comes out of the assets of the triple LP. So it's pretty similar to corporations and shareholders or members in the LLC. But remember, that's only allowed under UPA 2001 that you even have that, so not every state allows for that. Professional limited liability companies, you did a task on that when you were trying to convert general partnerships into this. Just keep in mind, not personally liable for the torts of the entity, right? You're, of course, always liable for your own negligence or wrongful acts or debt, but you're not liable for the responsibilities of the actual LLC. You might be liable, for example, if you're a lawyer and you've got paralegals who are working with, or legal secretaries, or law students that are interns. You might be liable for failure to properly supervise and control them. But again, this is where you bring in professional liability insurance to try to protect you. And then a limited liability company, not personally liable. You're only liable for your own torts, or if you are a member manager and you've breached your fiduciary duties to the entity, but outside of that, limited liability. Questions on that, folks? So think of the general partnership and the sole proprietorship as the worst of all worlds, because those are the unlimited personal liability, and everything else has an opportunity for limited liability unless you're a GP in a limited partnership. All right? What happens if a limited partner or a member wants to bring an action? We talked about there's two kinds of actions. One is the direct action, the claim that they've basically violated one of your statutory rights, typically your right to inspect or audit the books. Derivative actions, look at the Zales case, right, where the court had to make a decision. Could you have the members acting on behalf of either the limited partnership, if it was a limited partnership, or in Zales, the LLC? All right, and what you can say is, well, you can bring that action if you first made a demand on the general partner in the limited partnership or the manager member to try to enforce that right, and they wrongfully refused. Or you're able to show a court, hey, if I was asking them to enforce it, it would be useless, it would be futile, because they're probably the ones involved in the wrongdoing. Remember, if you're going to bring that action as either the limited partner or the member, you've got to be there at the time the dispute arose, as well as the time the legal action is filed. Otherwise, you can't bring those actions. All right? And then dissolution and disassociation. We talked about the fact that it can be voluntary in the partnership situation by partner actions. Involuntary, that's often the court is ordering or some kind of administrative action against you. And then Creel is a good example of this battle about what happens if people want to leave the partnership. So if you looked at UPA, there was automatically triggered dissolution of the partnership if one of the general partners wanted to leave, unless you had a continuation agreement at the time you formed it, or after the party decides they want to leave, you can all come to agreement on post-dissolution. That was the problem in that case. There was no actual continuation agreement, although the court read the partnership agreement pretty broadly. But Mrs. Creel said, hey, I don't want this to continue. I want them to liquidate so we can determine the true value of the partnership. Now, normally under UPA, that's what happens, right? This idea that if somebody leaves, you're going to liquidate the partnership assets. But we know over time, the courts have tried to soften that because of the fear that you're going to have a fire sale every time anybody leaves, and it might be a bad time to sell the partnership, depending on what's going on in the economy. So what the courts will do is, well, let's do a good faith winding up, which basically means have some objective third party who can evaluate the true value of the partnership and buy that party out. But if you actually look at the language of UPA, if somebody leaves, that's supposed to trigger dissolution and the winding up and termination of the general partnership. We know under RUPA, though, they don't want that. That's totally thrown out the window. We want continuity. We want stability in partnership entities. So it's all about the buyout. It's all about the buyout. And normally you're not liquidating and terminating unless you absolutely have to, which is that you don't have enough money to buy out a partner. I think Matt asked me about this. Yeah, I think Matt asked me about this one time. But keep in mind that if somebody exits and you can't afford to buy them out, you may end up having to liquidate. But if you put some money aside, you have some insurance in place to deal with these kinds of situations, you might be able to continue. So keep that in mind. And of course, as we know, creditors always get paid first, partners at the end of the line here, right? And then of course, if somebody disassociates, you file that statement or certificate of disassociation, because in essence, you want to identify the partner who no longer is with the entity, and then once that's been filed, 90 days after it becomes effective. So people are viewed as on notice that this person's not part of the partnership anymore. And then the certificate of dissolution, you're basically canceling all the statements of authority and putting the world on notice that the business is dissolving and winding up. It's the same thing for the RLLP and the LLP as it is for the GP. So it's very similar in approach. It's not all that distinct. You might see a little bit of distinction between the LP disassociation and the general partnership disassociation. The general partner, right, if they withdraw, it's not an automatic dissolution because, first of all, there might be other general partners that can still run the business. And so the limited partnership agreement may allow this to continue, or all the remaining partners will agree in writing within 90 days that we want this to continue, and if we've got no general partner, we'll put in a new general partner to replace the one that's left. And under UPA 2001, it's a majority. Now remember, it's all of the remaining partners here under UPA. It's a majority of the remaining partners if they want to continue. So it's a little bit of a distinction there. One's kind of an all or nothing. The other is, well, if you get a majority of people to agree, it will continue on. What if a limited partner wants to get out? Well, normally you can disassociate with 6 months' notice, partly because you want to give time for the other partners to perhaps replace whatever investment you made in the business entity, which could be important, and it'll give them a chance to assess the value and make any payout to you that is potentially owed to you, as long as you are not harming creditor rights. So you're not paying out so much to that limited partner that you're not living up to your debts as a limited partnership. If you look at UPA 2001, there's no automatic right to dissociate before winding up. So if you agreed that this was going to last for 5 years, you're going to hang in there for 5 years. If you decide to leave, then it might be viewed as wrongful, and the other parties could sue you for damages if you damage the entity by leaving. So you can disassociate, but realize there might be a price to pay if you do so. So by written notice, or if an event in the limited partnership agreement, like we had this LP to develop this piece of real estate, it's been developed, the thing is over now, you've been expelled usually for bad conduct, or by termination deciding that they're just going to end the LP business entity as a whole. Just keep in mind, wrongful disassociation could be damages. All right, what about when you're not dissolving it on your own as the LP? When you've got the non-judicial part of it, we've talked about this, that if there's some time or event stated in there, ends it. Written consent of all the partners under UPA, majority of the partners under UPA 2001, or if you find out that the thing has gone forward and the last general partner has withdrawn and there's no continuity provision in the partnership agreement, or no majority vote to allow it to continue on with a new GP after 90 days. Under UPA 2001, 90 days after disassociation of the last LP, or if only one general partner remains and there's no LP, that's going to lead to the end of the entity. You can also always be administratively dissolved by the Secretary of State. You didn't pay your fees, you didn't file your reports, you didn't live up to your requirements. And then you can at times go to court, and then, although the courts don't like to get involved in this, but you can go into court to try to seek dissolution. And then if you do dissolve, you still have to file one more piece of paper, the certificate of cancellation with the Secretary of State's office that puts everyone on notice that the LP is done and over with. All right, the LLC, very similar, right? So folks, think about it. There's always these voluntary ones, there's always these judicial ones, and there's always these administrative angles. So there's a lot of similarity between them. So with the voluntary, certain events specified in the operating agreement, we built the building, we're done. All the members consent, all right, we want this organization to dissolve. Or if 90 days pass in which there are no LLC members. You might have a manager managing it who's not a member. So if you're getting to that point, it's time to close up shop. That's voluntary dissolution. We know the courts don't like to get involved in this, but if you look at 1545 Ocean Avenue, they talk about the fact that, well, if they aren't carrying on the business, if it's no longer reasonably practical, then a court will step in, but they're reluctant to do so. And we know the court there said, remember the cowboy and the risk-averse guy were in the same business together. The court says, we don't want to step in it. Everything's not a smooth glide to profitability. There might be a bumpy road. So if you're going to say it's not reasonably practicable, then what you're really saying is that the management is unwilling to carry forth or to promote the entity's goals and objectives, or if continuing the entity is not possible because it's not financially feasible. Alternatively, if you can show that the person who's running the entity has acted fraudulently or illegally or oppressively to the other parties, that could be another ground for getting the court to dissolve it, but the court don't like to do that. Administrative, again, it's always that, did you file your report? Did you pay your fees? So that you see throughout all of these. All right, disassociation and dissolution. Remember, this idea, voluntary. That's by the members' action. So there's examples here, members' death or incapacity, fulfilling the goals of the operating agreement. Somebody withdraws with prior notice. But again, you could always have wrongful disassociation. So go back to the operating agreement and see what it says about the grounds for disassociation. Now, the LLC, because it's like the corporation, it can continue despite a disassociation, right? So the idea is similar to RUPA, you can buy out that member that wants to go. Or it may be a case that they want to leave and they don't have a right to, then you can sue them for damages for harming the LLC. But just because somebody leaves, it does not mean that the LLC is going to go away. It can have perpetual duration, like a corporation. The winding up, very similar to the others, right? Accurate accounting, what do we have, what do we owe, who owes us money, what are all of our assets, third-party creditors first, then if there's members who have made loans, then if there's any remaining funds, it's exactly like the partnership, right? Creditors first, any partners that have given loans to the partnership, and then if anything's left, then the partners get it. Oftentimes there's nothing left. And then termination, that's when the LLC ceases doing business. That's where you have to file the articles of termination or dissolution with the Secretary of State to end the business entity. And that is it. Oh my God, we covered a lot, didn't we? But remember, folks, try to think about the patterns. There's a lot of similarities here. So things like voting, very similar. Things like dissolution, there's some minor tweaks between them, but there's not huge differences, daylight between them. Now, questions, folks. We still have a little bit of time. Any questions that any of you have?